That is how it is understood everywhere in the world. It is today in India, it is no longer about rights. It is about policy decisions. Say, for instance, appointment of a judges, for the judges of this country have to be appointed, is a matter of executive and legislative policy. And in matters of policy, whose will has to prevail? When a parliament, see, we may have a difference of opinion about our MPs. Our MPs may be corrupt, many may be incompetent, but they represent the people. When a parliament enacts a law, the record of a parliament, when a parliament enacts a law, we are all symbolically present in the parliament, and we are all party to it. It binds everyone. When a court enacts a law, the record of a court, we can only bind the parties before it, because court has only heard those who are before it. And to extend a decision of a court, a place even higher than of a legislation, is most undemocratic. What happened in NJSC case? The decision of the parliament, both houses of the parliament, unanimous, except for the dissenting voice of Ramjat Rani, and which has received the law NJSC, which has received the assent of the majority of the state, was struck down by the Supreme Court because 4 judges disagreed. This is outrageous. So therefore, all this mischief could be done in the name of basic structure. So I consider it is my duty to tell that this basic structure theory is absolutely has nothing to do with jurisprudence. Anyone who has the elementary knowledge of jurisprudence would find that this is an absurd proposition. It can be discussed in Parliament. That's as a political philosophy, not as a jurisprudential principle. And I asked them, see, suppose the basic structure is all about basic. If fundamental rights can be all abrogated, taken away, and all, then if fundamental rights has to be minus fundamental rights, it has to be removed from the concept of basic structure. What exists? The question is, if fundamental rights can be infringed and the basic structure remains, what use it is? On the contrary, the basic structure is abrogated, destroyed, but fundamental rights are protected. Then why should one worry about the destruction of the basic structure? So this is a concept which is absolutely illogical. It has nothing to do with the jurisprudence, and the people of this country has been fooled, I'm sorry to say.
Sir, you have given a lot of detail about this basic structure. But let us understand, since this was a creation of the Keshavanand Bharati judgment, did the judgment describe what is the basic structure, or what are the things which are covered in the basic structure?
The basic structure concept being totally alien to the concept of jurisprudence. You read any number of classical works of jurisprudence, nowhere you will find the word basic structure. So then in the Keshavananda Bharati's case and in the subsequent judgment, Bombay's case, Minerva Mill's case, all these cases, Nagaraj's case, all these cases, the court ventured to state what probably could be are the basic structures. So independence of the judiciary is a basic structure. That is what all about the Judges 2 case, NJSC case and all. Then other concept, secularism, a basic structure. The federal structure of the constitution is a basic structure. These are all, but these are all non-legal principles. My question, these are not issues of concerning jurisprudence. These are political theory. So if it is the basic structure theory, if it is understood as a political philosophy, I have no disagreement. If somebody asks me, should India remain as a secular country? Yes, certainly. But the moment if the secularism is infringed, it leads to violation of fundamental rights. So we need only say fundamental rights to be protected. You don't have to use a meaningless term or a vague term or basic structure. So then independence of judiciary. So then independence of judiciary, when the judges are not independent, then there is no justice delivery system at all. Your fundamental rights are affected. So the basic structure, then the federal structure of the constitution. These are the political philosophies. So these issues can be discussed in parliament. When a law is enacted, they can say this affects the our secular. So today, UCC bill is likely to be piloted. Then on a discussion on UCC, they can say this affects their basic structure, or the concept of secularism, or the rights of minorities, or the such things can be possible. But it is not a subject which can ever be raised in a court. In a court, the subject which can be raised is rights, remedies, and a forum to enforce it. If nothing else can ever be visualized in the context of a court. So otherwise, if it is used in the parliament and general parliaments, I have nothing against it. I am only at the think of the calamities he has done. The other day, there is an article, a book I read, where it is said only 93 seconds are the average time which is given for hearing to argue a case. An SMP is 93 seconds. So when it comes to the constitution, there are certain fundamental flaws in the constitution. I said in the Article 32, the Supreme Court as a court of original jurisdiction, it is absolutely impractical, and it's against the basic jurisprudence also. The jurisprudence, what is the scheme of jurisprudence in any country is that all causes, all parties be brought before one forum, and it allows decision to be final, subject to appeal. And in all legal systems, there's a provision for appeal, because humans are fallible. So there should be a corrective mechanism, at least one form of appeal. So when you draw up a constitution which has in consonance with the legal principles, you cannot ever imagine of Supreme Court was the first court of original jurisdiction, except in matters of interstate dispute, etc. But concerning the rights of private individuals, Supreme Court, the original court of jurisdiction should be the district court, right of appeal to the High Court, and the Supreme Court the second appeal. And certainly it was a great mistake to have incorporated Article 32 in the Constitution, from a theoretical angle. Now, look at from the practical angle. If Article 32, any citizen can approach the Supreme Court for enforcement of his rights without recourse to another court, then that right should be available to every citizen. And in a country of 140 crores of people, it should not be that people in Delhi and the rich and the powerful alone could be able to access it. If it means equality before law and equal protection of law, means everybody should be able to approach the Supreme Court. In which case, you may probably need a Supreme Court of 500 judges, 1,000 judges. It is absolutely impractical.